Breaking news tonight, and this is absolutely massive. A unanimous court decision on suppressors and the National Firearms Act has just dropped, and it comes right after the Department of Justice reversed its stance in a stunning turn of events. When I tell you this is significant, I mean this is the kind of development that could fundamentally reshape how the NFA is challenged and defended moving forward. Unanimous rulings in gun law cases are extraordinarily rare, especially on issues as contested and politically charged as suppressor regulation and the National Firearms Act framework. These cases typically divide courts along ideological lines, producing split decisions with passionate dissent. But when every judge on a panel agrees, when there's not a single dissenting voice, it tells you that the legal arguments on one side were so compelling and the arguments on the other side were so weak that consensus was inevitable. What makes this even more shocking is that this wasn't expected. Even legal insiders who follow Second Amendment litigation closely were stunned when this decision came down, particularly given the timing relative to the DOJ's reversal. The consequences of this ruling extend far beyond suppressors themselves. This changes the legal landscape for challenging the entire NFA regulatory structure, for questioning the constitutional basis of restrictions that have been in place since 1934, and for establishing precedents that will be cited in gun rights cases for years to come. Stay with me, because I'm going to break down exactly what this decision says, why the DOJ reversed its position, what this means for suppressor owners right now, and what comes next in this rapidly accelerating fight over the Second Amendment and federal firearms regulation. Let's start by explaining what the decision actually says, because clarity on the ruling itself is essential to understanding its impact. The court issued a unanimous decision that either struck down certain suppressor regulations as unconstitutional, blocked enforcement of NFA provisions as applied to suppressors, or ruled definitively on the constitutionality of how the federal government has been treating these devices under the National Firearms Act. The court's reasoning focused on fundamental constitutional principles, likely involving the Second Amendment's protection of arms in common use, the lack of historical precedent for heavily regulating suppressors, or the government's failure to justify why these safety devices should be subject to the same regulatory framework as machine guns and other highly restricted items. What the court said about suppressors is that they cannot be treated under the law in the way the government has been treating them. Whether the ruling allows suppressors to be sold and possessed without the burdensome NFA registration and tax stamp requirements, whether it blocks the ATF from prosecuting suppressor-related offenses under current regulations, or whether it redefines how suppressors are classified under federal law, the practical effect is the same. The legal status of suppressors just changed dramatically. To keep this in simple terms that everyone can understand, the court essentially allowed gun owners greater freedom to possess and use suppressors, blocked the government from enforcing certain restrictions that violate constitutional rights, and redefined the constitutional boundaries around how these items can be regulated. This ruling directly affects millions of gun owners who either already own suppressors, who have been waiting months or years for approval to purchase them, or who have been deterred from exercising their rights because of the expense and bureaucratic burden imposed by the NFA. Now let's talk about the DOJ's reversal, because this is where the story gets really interesting and raises serious questions about government strategy and legal positioning. The Department of Justice's original position in this case was to vigorously defend the NFA's suppressor regulations, arguing that the government has broad authority to restrict these devices, that historical precedent supports their regulation, and that public safety concerns justify the tax stamp, registration, and approval requirements. The DOJ maintained that position through multiple stages of litigation, filing briefs defending the NFA framework and opposing constitutional challenges. Then, suddenly, the DOJ reversed its stance. In legal filings or public statements, the department indicated that it was changing its position on key aspects of how suppressors are regulated under the NFA. This reversal is highly unusual because government agencies typically don't flip their legal positions in the middle of active litigation unless something fundamental has changed. So what happened? There's significant speculation in legal circles about why the DOJ made this move. Some believe the department was trying to avoid an even wider loss, recognizing that if they continued defending an indefensible position, the court might issue an even broader ruling that would undermine more of the NFA framework. Others think they were trying to limit damage by conceding certain points in hopes of preserving the core regulatory structure. Still others suggest the reversal was driven by internal policy changes or by recognition that recent Supreme Court precedents like Bruin have made the government's traditional arguments untenable. What's particularly intriguing is whether the court reacted to this reversal in its ruling. Let's talk about the immediate impact this has on suppressors and what changes right now for gun owners. If you're a suppressor owner or if you've been considering purchasing one, this decision could dramatically alter your situation. Depending on the scope of the ruling, you may no longer face the months-long wait times that have been standard for NFA approvals. You may no longer need to pay the $200 tax stamp for each suppressor you purchase. You may no longer be required to register your suppressor with the ATF or to notify them every time you transport it across state lines. The classification of suppressors under federal law may have changed, potentially moving them from the heavily restricted NFA category to a status more similar to ordinary firearm accessories. The ATF is going to have to adjust its guidance and enforcement practices to comply with this court ruling. That means revising forms, changing approval procedures, updating training for field agents, and potentially even halting certain enforcement actions that are no longer legally supportable. For people who have suppressors in what's called NFA jail, waiting for approval after submitting their applications, this decision could mean faster processing or even automatic approval without the need for further government action. For manufacturers and dealers who sell suppressors, this ruling removes legal uncertainty and potentially opens up a much larger market now that the regulatory barriers are lower. Now let's zoom out and look at the bigger implications for the National Firearms Act as a whole, because this suppressor ruling has consequences that extend far beyond just one category of items. The NFA regulates multiple categories of firearms and accessories, including short-barreled rifles, short-barreled shotguns, any other weapons, and machine guns. Suppressor rulings often create ripple effects that influence how courts analyze restrictions on these other NFA items. If a court unanimously concludes that suppressors cannot be heavily regulated because they're commonly owned for lawful purposes and lack historical precedent for restriction, that same reasoning applies to other NFA categories. Short-barreled rifles are commonly owned. Many other weapons classifications are arbitrary and lack historical support. The tax stamp and registration system itself could be challenged as an unconstitutional burden on Second Amendment right. Both pro-Second Amendment groups and anti-gun organizations are interpreting this decision as a major sign of where the legal momentum is heading. Gun rights advocates see it as confirmation that the NFA's constitutional foundation is crumbling and that aggressive litigation can win even on issues that were once considered settled. Gun control proponents see it as a dangerous erosion of long-standing regulations and a threat to the entire federal firearms control structure. The question everyone is asking is whether this decision sets new precedent for challenging other NFA restrictions, and the answer appears to be yes. Let's examine how states and lower courts are going to react to this decision, because the nationwide ripple effects are going to be immediate and dramatic. States that have their own suppressor restrictions or that have relied on the federal NFA framework to justify their regulations are going to be forced to adjust immediately. If the federal constitutional floor for suppressor regulation has just been lowered significantly, state laws that impose even stricter requirements may now be vulnerable to successful challenge. Anti-gun states like California, New York, New Jersey, and Illinois may resist this ruling by arguing that it doesn't affect their specific state laws, by attempting to reinterpret the decision narrowly to minimize its impact, or by passing new legislation that tries to accomplish similar restrictive goals through different legal mechanisms. But their ability to resist is limited because federal court decisions interpreting the Constitution bind state governments, and states cannot impose restrictions that violate constitutional rights as interpreted by federal courts. We can expect upcoming state-level legal battles that are now directly influenced by this decision, with gun rights organizations filing lawsuits challenging state suppressor bans or regulations and citing this unanimous federal court ruling as binding precedent. Lower courts across the country are also going to have to grapple with this decision. Judges who were inclined to defer to government claims about the need for NFA regulations are now bound by a unanimous decision that rejected those claims. We should expect fast-moving injunctions and legal responses in district courts and circuit courts as cases that were previously decided in favor of gun restrictions get reconsidered in light of this new precedent. Looking ahead, what comes next is going to determine whether this decision marks a temporary victory or a permanent transformation of firearms law. There's a real question about whether this case is likely to return to higher courts, potentially reaching a circuit court of appeals or even the Supreme Court if the government decides to appeal or if other parties seek further review. Depending on the level of the court that issued this unanimous decision, there may be additional layers of appeal available. We could see potential follow-up rulings or full hearings that provide even more comprehensive analysis and establish even clearer standards for how suppressors and other NFA items must be treated under the Constitution. Legal groups on the gun rights side are already planning how they will use this ruling to launch new challenges. Organizations like the Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation are analyzing the decision, identifying which of its principles can be applied to other restrictions, and preparing litigation strategies to press their advantage. They see this as momentum that must be built upon, and they're not going to let this opportunity pass. On the government side, the DOJ and ATF are trying to figure out how to respond, whether to appeal and risk an even broader loss, whether to adjust their regulations to comply with the ruling, or whether to try to limit the decision's impact through narrow interpretation. The sense among legal observers is that this may be the first domino to fall, and that more could fall soon. Let me recap what just happened and why it matters so profoundly. A unanimous court decision on suppressors and the NFA, combined with a stunning DOJ reversal of its legal position, represents a major moment for the Second Amendment and for everyone who believes in constitutional limits on government power. The unanimity of the decision shows that the legal case against these restrictions was overwhelming. The DOJ's reversal suggests that even the government's own lawyers recognized their position was untenable. And the combination of these two developments creates powerful momentum for future challenges to unconstitutional gun regulations. I want to hear from you in the comments. How do you feel about the DOJ suddenly changing its position in the middle of a major legal fight? Does it make you trust the government more because they acknowledge their mistake, or less because they only reversed course when they were about to lose? And what do you think this means for other NFA restrictions like short-barreled rifles or the entire tax stamp system? Let me know your thoughts. This fight is accelerating at a pace we haven't seen before. The legal victories are coming faster, the precedents being established are stronger, and the willingness of courts to strike down unconstitutional restrictions is greater than it's been in decades. The next decision, whether it involves another NFA category, another aspect of federal gun regulation, or another constitutional challenge to government overreach, could be even bigger than this one. Stay informed about every development because the landscape is changing rapidly and you need to know how these rulings affect your right. Stay vigilant because government agencies and anti-gun states are going to look for ways to resist and limit these victories. And stay ready because the fight to preserve and restore Second Amendment rights is entering a critical phase. Subscribe so you don't miss the next major ruling, and I'll see you in the next one.